Good morning. My name is Chris Powell, and I'm an attorney at Hanson Bridget LLP in Sacramento, California, representing Rise Grass Valley, Inc. in support of its vested rights petition. I'm a land use attorney, and my specialty throughout my career has been mining law. Relevant for today, my mining practice includes work on vested rights claims, mineral title opinions. Mineral title opinions are where you look at the actual deeds and figure out if severed mineral rights have been reserved, used for insurance and transactions, and work involving patented and unpatented mining claims. Let me introduce the Rise team. Right here we have Joe Mullen, the CEO. We have directors Dan Oliver, John Proust, and Ben Mossman. Also, we have Megan Wold, attorney at Cooper & Kirk, PLLC, and Naran Samasundram, attorney at Hanson Bridget. I'd like to go through just the presentation contents we're going to be talking about today. Number one, process and procedural context of a vested rights determination. Number two, the key concepts and applicable law. Number three, property overview. 4, evidence of mining and vested rights. 5, staff report errors. 6, no abandonment. We're going to discuss the evidence surrounding abandonment. 7, the scope of the vested right. Where is it? How much? What types of operations? And 8, conclusion. We're going to request that the board reject the staff report's findings and find that, in fact, a vested right was created and it has not been abandoned. So first concept here, and I think this is an important one, a vested rights determination is not a discretionary approval. So this is unlike a use permit hearing, unlike a general plan amendment, specific plan where policy comes into play, and you're weighing different factors and the public good. This is different. This is weighing evidence and applying a legal standard to come up with an unbiased conclusion. Outside counsel said explicitly earlier, she said, and I believe this is a pretty accurate quote, "We don't have enough information to determine 100% that the vested right existed." I agree. You never have 100%. That's not the legal test. The legal test is greater than 50%. We've definitely provided that, which we'll go through in a minute. And I think as we go through the presentation, you'll see the reason they reached the conclusion that they reached is they were applying the wrong legal standards for existence of a right and for abandonment. Did the owner have intention and take an action or an omission that completely forecloses future mining? A vested right does not exempt the operator from CEQA, the Clean Water Act, the Clean Air Act, Endangered Species Act, or any other applicable environmental law. I know it's a very scary concept that a mine operator might not need a use permit, but there are countless other laws that apply to a mine operator, even with vested rights. So this slide here includes text from the Fifth Amendment to the U.S. Constitution and the California Constitution, both of which prohibit taking of private property for public use without just compensation. The Hanson Brothers case is the seminal mining case regarding vested mining rights in California. The Supreme Court of California overturned the county's decision, holding that a constitutionally protected vested right could only be terminated if abandoned. Most legal non-conforming uses, let's say a restaurant, they're not allowed to expand their use over time. They can't keep building out and add new patios and go on to other parcels. But the Supreme Court of California said mining uses are different. Naturally, they have to expand. You can't mine if you can't make your mine bigger. So this is a different class of legal non-conforming use than your typical restaurant or maybe apartment that's in the wrong zone. The court looked very carefully at the type of use, the type of constitutionally protected property right that was at issue at that case. And they said surface mining is different than other types of uses, and we need to consider that to determine whether or not there's actually been actions that cause abandonment. Therefore, sometimes they're mining over here or mining over there, or they'll be dark when there's no work to do because there's no market for their materials. And in that context, that's not considered abandonment, just to run your business in accordance with the market, even going dark for long periods of time. 175 acres of surface land we've talked about. That's a 119-acre Brunswick industrial site, 56-acre Centennial industrial site. It's been stated in the staff report and by counsel that all these pieces were sold off. That is really not true. There's lots of deeds of record where other pieces were sold off that are not even part of the property. Surface properties were sold off, and yes, they were developed into houses. That's not part of our petition. We're not claiming vested rights on any of those properties that were sold off and are no longer, owned by Rise. Everything that we're talking about right now is this 175-acre area that is owned by Rise, and then all the mineral rights within the 2,560 acre area, I can tell you with 100% certainty the mineral rights are owned by Rise. So next, what I'd like to go into is evidence of mining and vested rights. This shows you that over the years, the mine opened and closed and flooded and was pumped out, multiple times. Nearly a dozen times where the various parts of the mine or the entirety of the mine flooded and reopened, and equipment sold off, and then new equipment bought, bigger and better, new workers hired, and they went back to work, and then they didn't find what they wanted to find. They closed down, they reopened. This happened over and over, and that's important to recognize because today you need to consider the character of this property, the character of the constitutional right that vested, and you'll determine was abandoned or wasn't abandoned. And that character is special and it's different than other types of property rights. And I think this is one of the stronger pieces of information. This is the annual report from Idaho Maryland Mines Corporation in 1955. I think that pretty much answers the question. Yes, mining was ongoing in 1955 after this ordinance went into place. And I know the staff report said, well, we don't have enough information. And we've stated in our letter, and you've heard it today, and I'll reiterate it throughout my presentation, they're applying the wrong legal standard. I think they're confused about what the standard is, unfortunately. It's not 100% certainty. I agree with her. There isn't 100% certainty, but definitely a preponderance of the evidence that mining was ongoing. They said in their own report, they pulled out 28,905 tons in 1955.